companies. I was involved in this 2015 hearing in which we asked for you to deny Credit Suisse a waiver. Instead, the Department of Labor decided to give them a 5-year waiver, and then they extended that in 2019. We're seeing the consequences of that in just the last 2 years. Credit Suisse pled guilty in Mozambique, to defrauding Mozambique in the Justice Department case in November 2021. It has been revealed to be engaged in all kinds of other activities, misbehavior since 2015. Most recently, lacking compliance with its own deferred prosecution agreement, which was signed in 2014. But now Credit Suisse is down to number 51 on the list of international pension sort of asset managers, and is only running about $800 billion of funds. The other names on the list of the top 30 include some firms that we are very concerned about as people who have spent a great deal of time investigating what's the behavior of financial institutions around the planet. My favorites on the list are HSBC, which I have written about their behavior in South Africa with respect to the Zumagate investigation. John can talk further about his investigations of HSBC. Morgan Stanley, I recently investigated their engagement in a outrageous case of facilitating tax evasion from some of the wealthiest white people in South Africa, setting up schemes of 15 offshore companies to have a round-trip scheme. This is the kind of thing that I submit ordinary pension fund managers are not going to come across. We are talking about serious crimes and serious patterns of misconduct by these financial institutions. It's not isolated events. It's not rogues. It's required institutional, systemic misbehavior. And that's what I think your reform should be focusing on. The third thing I'm concerned about here, in addition to the list, in addition to targeting this serious misconduct and making sure that people in the industry understand that it will be taken seriously, is the budget for DOL to enforce this activity. I would hope that you would, in your considerations here, let us know what you have in mind for requirements, so we can go to work and defend the kind of increased resources that I see the Department of Labor needing to make this proposal actually effective. This is, by our definition, a very conservative approach. This is about the rule of law. It is about enforcing very reasonable standards that have been in existence for a long time, that some of these organizations have systematically violated. And I would say that if we had the kind of rules that you're suggesting in place, let's say in 1999, when Credit Suisse was involved in a huge tax evasion conviction in Japan, we might have avoided not only its involvement in the Enron matter, in the tax dodging that we saw in 2014, in a lot of the other misbehavior, but we might actually have saved Credit Suisse itself from its demise. It may be that certain kinds of activities that they were engaged in, they thought were more profitable because they were able to get away with them. But in the long run, these things come to the surface, and no one wants to work at those kinds of institutions. So what we're suggesting is very reasonable, modest regulation. It is a good answer to the question of why we don't want to eliminate QPAM regulation. The industry actually needs us to be more effective, not less. That's my remark. Thanks very much for the opportunity to testify. We can submit and revise our remarks accordingly. Happy to take questions.
Thank you. We have two more presenters, right, on the panel.
Yes, John.
On the agenda,
Okay, Dr.
Paul,
Paul.
you want to go ahead? By all means.
Yeah.
All right, thank you. The DOL is responsible for oversight of QPAMs, but it can't do this without a list and adequate authority. For example, in 1999, Credit Suisse was criminally convicted in Japan. It helped 60 banks and companies hide huge losses. Basically, CS cooked the books. CS directed that documents be shredded, destroyed, or sent immediately to the firm's offices in London beyond the reach of the regulators, even during an audit by the regulator. Credit Suisse didn't apologise. It said it considered the punishment disproportionate. The Japanese said that CS had deeply undermined the soundness of Japanese financial institutions. The bank's deceptions were planned and systematic, involved the entire organisation in Tokyo, not just a few individuals. There was obstruction of criminal investigations, lying to the regulator, evidence destruction, market manipulation, systematically falsifying documentation, and conducting business without a license. This pattern of wrongdoing has repeated multiple times since then. The CS division in Japan changed its name twice, finally to Credit Suisse International, or CSI. Remember that name, it will repeat. Next year, Credit Suisse in India was caught in market manipulation. It confessed to a fraudulent scheme of synchronized, circular, and fictitious trades, which created artificial volumes, markets, and share prices. It was convicted from trading for 2 years, but the appeals tribunal stated this was unjustifiably lenient. This emphasises that foreign convictions are more likely to be lenient, not severe. Next year, Credit Suisse in Switzerland was caught red-handed in market manipulation again, plus embezzlement and fraud, the CS-TNST case. Just like in the previous cases, it initially denied any wrongdoing. However, this time it was on home ground. There was a criminal investigation. The prosecutor asked for the documents, but CS simply refused to produce the documents or destroyed documents, hid witnesses, lied, and even used bank secrecy to conceal its participation. When any member of the investigation got too close to the truth, he disappeared from the case. Eventually, the prosecutor had no resources left and closed the case. He told us that there was not a single prosecutor in Switzerland who would go up against CS. I went to the Zurich Supreme Court and copied the criminal investigation files. This revealed shocking details of a criminal enterprise operating through multiple CS organisations in different countries. Terrifying conclusions, but later confirmed in other cases. I met with CS legal departments several times. They refused to look at the documents and even hacked into our website. I told them I knew what went on and that they had stolen the honest savings of thousands of hard-working taxpayers. I shared my investigation with every major law enforcement agency and regulator. That is why Criminal Bank and QPAM, Credit Suisse, is in such a mess. There is worse to come for it because I know their books are not true. Last quarter, they wrote down $4 billion. They were deferred tax assets, which have been logged as hard capital, highest quality CET1 core capital. That was absurd, and they knew it. The bank's market cap is now only $11 billion. Continuing on. CS was skilled at not only cooking its own books, but for others too. CS hid losses for Enron. That became the US's biggest bankruptcy at the time. CS hid losses for Parmalat. That was Europe's biggest bankruptcy. Thousands of pension funds and old people were damaged. CS should have been stopped after their Japanese criminal conviction. The DOL could have been instrumental. There have been dozens of scandals, even financing Iran's nuclear program. That was a deferred prosecution agreement. You can't give QPAM privileges to a terrorist enabler. CS Switzerland and CS Securities Europe were criminally convicted for defrauding investors with Mozambique's billion-dollar fake loans. The Mozambique economy collapsed. 2 million people were trashed into abject poverty. This is how it was enabled. The head of CS Global Financing Group rudely rejected a compliance request from a junior female compliance officer. He emailed, and I quote, "What the ... swear word this is about? There is some stupid UK regulatory requirement. She's going to be fired if she doesn't behave." Here, to behave in Credit Suisse meant to ignore compliance. In March 2020, CS lost $200 million closing the hedge fund Malachite Capital. Managers warned that procedures needed urgent updating to prevent a repeat. These warnings were ignored, and there was a near identical recurrence, just 28 times bigger, the Archegos catastrophe. There was near zero effective risk management. Peak exposure was 24 billion. The US operations were managed by CS Securities Europe. Yes, the one criminally convicted for Mozambique. They were way out of their depth. So in December 2020, Archegos was migrated from CS Securities Europe to, wait for it, criminal bank CSI, the one that was criminally convicted in Japan. Archegos collapsed. It was indicted for market manipulation, racketeering, having done $100 billion of damage. Imagine what would be possible if the DOL had authority to act on foreign convictions, DPAs, and so forth. Only then will it be possible for it to truly manage QPAM privileges. They can also alert the DOJ, SEC, Federal Reserve, Congress, and so on, as well as working with delinquent QPAMs, if it is possible to do that. $2 to $3 trillion of criminal proceeds gets laundered annually, much of it through pension funds who are generally not equipped for AML. Secretly, some big funds would not complain if laundered money made their results look good, as long as they didn't know. Democracy is dying because corrupt money buys power and political influence, now on a scale greater than ever before. Credit Suisse shows that dirty money can destroy the bank. So what the DOL has asked is just the starting point. It needs the funds to come back to the real world. They're living in a fantasy world, and as long as that fantasy world is propped up like a house of cards, they're going to whinge if anyone changes or imposes regulations, just like before the global financial crisis. When the crisis comes, the people they complained and wanted to get rid of, they're going to desperately need to come back to put it all back together. The world financial crisis is in a very fragile state. Leverage is beyond what was there in the lead up to the Great Recession. And there are several reasons why we can have what's so-called black swan events that can just knock the whole world's economy off its balance. Share markets are not realistic. People don't own the shares. It's all done on leverage finance, and we're moving from an era of low interest debt to high interest debt. The traditional outcome is what we could call stagflation with certainty. But there's not even that much certainty these days. The only certainty is a bad result is coming. And unless we start to clean up our house, try and do the best we can to get rid of the criminal money out of the pension funds so that they can stay stable and can survive the next financial crisis, then we're going to be in a lot of trouble. Thank you.
Thank you as well. And I think it's John Christensen. He's our last person on this panel.
Yeah. Thank you and good morning, and thank you for inviting me to submit to this hearing. My name is John Christensen. I'm attending this hearing from London, which is where I live and work. I'm the former chief executive and chair of the board of the Tax Justice Network, which is an NGO established to monitor and campaign for better regulation of financial services, particularly cross-border financial services. That's why I think that my experience is pertinent to this hearing. I practice as both a forensic auditor and an economist. And in the former capacity, I led on a number of major investigations into banking fraud, including an investigation into an offshore subsidiary of the Swiss banking giant UBS. And that investigation, after many years of denial of any malfeasance or wrongdoing, led to the subsidiary bank in question, which was called Cantrade Bank, pleading guilty to criminal recklessness in its treatment of its clients' affairs. I also work as a documentary filmmaker, and Jim earlier talked about HSBC. One of the films I made with a French French-German team is called, and this gives, the title gives you tells you exactly what it does. The film title was HSBC, The Gangsters of Finance. And that film explores the role that HSBC played over many years and in many countries in facilitating money laundering and tax evasion on a global scale. And that included in the United States, where HSBC was investigated by the Department of Justice and paid a record out-of-court settlement. Now, I'd like to make an observation flowing from that, because HSBC, in common with many of the big financial institutions, has made a habit of avoiding criminal prosecution through negotiation of non-prosecution agreements or deferred prosecution agreements in order to avoid having a criminal record. Sometimes they do actually get a criminal record, quite rightly, but they have a track record going around the circuits here. And I think this is pertinent to this hearing because I feel very strongly that the Department of Labour needs to take account of all such agreements, non-prosecution, delayed prosecution, or whatever, when it goes about the job of assessing whether a QPAM exemption remains valid. But also I think DOL needs to look at qualifying QPAMs in the round and take account of prosecutions, non-prosecution agreements and deferred prosecution agreements, not just in the United States, but across the world, as Jim and Paul have just explained. Now, one of the more shocking insights I gained from working in international finance for over 4 decades now is that so much of the banking fraud and the monkey business that we investigate across the continents is at root caused by political failure and misunderstanding of basic economics. I said I trained as an economist. And I'm thinking in particular of the protracted periods of competitive deregulation that we've seen globally in the finance industry in the 1980s, 1990s, which inexorably led to the 2008 banking collapse. And I'm thinking that the lessons that were learned coming out of that collapse have subsequently been unlearned in recent years. And the lobbyists are back out there saying, we don't recognize the need for regulation or indeed tight compliance procedures because, we're doing fine at the moment. But as Paul just said, we are facing a period of almost unrivaled. I think the fragility of the financial sector is much, much worse than it was in the build-up to the 2008 crisis. But unfortunately, this language of competitiveness has become so deeply rooted in our political economic thinking that we seldom give a second thought to what it actually refers to. I hear financial advisors and politicians using this word, and everyone nods along in agreement because they think this is a crucial part of how markets work. But when I hear bankers and financial lobbyists and politicians using that term competitiveness, more often than not, they're talking about something entirely different from the type of microeconomic competition that occurs in other markets. For bankers, competitiveness involves engaging in a race to the bottom that pits one jurisdiction against another in a process of competitive deregulation and tax competition. They don't think in terms of lowering fees to their clients or providing better services to their customers. When they lobby in the name of competitiveness, and I've heard this more and more often in the last few years, they're generally pushing back against regulation, against anti-money laundering regulation in many cases, or against progressive taxes like the financial transaction tax. So, for bankers, competitiveness translates into lax know-your-client regimes, weak compliance with anti-money laundering regimes, lower capital adequacy ratios, and inevitably state-funded bailouts when the poo hits the fan, as it does all too regularly. And I agree with Paul, by the way. I think we're heading for the mother and father of all crisis. But far too often when banks are caught out in financial frauds or assisting clients with tax cheating or other financial crimes, they wriggle free from the consequences by settling out of court in order to avoid conviction and consequential reputational harm. But here in London, politicians interpret competitiveness to mean engaging in competitive deregulation to bring the City of London financial regulation standards and compliance standards down to those of tax havens like Dubai or Singapore. For its part, the Bank of England, which of course is responsible for banking regulation in Britain, they've been flagging concerns up about the systemic threats that have been steadily building up for pension funds and other major asset managers as a result of poorly managed debt leverage and the lack of transparency about debt liabilities in the shadow banking sector. And I think this is relevant to this hearing. Earlier this week, senior Bank of England officials stated that the chaos facing pension funds in London in late September, some of you might have heard about the so-called mini budget crisis coming out of the government led by Prime Minister Liz Truss. That crisis for the pension sector arose from a liquidity crisis caused by overuse of leverage liability-driven investment strategies. And these are widely used within the pension industry as a hedging mechanism. Now, as much as anything, that the chaos which came out of the mini budget posed an existential threat to some of the pension funds operating out of London. In many cases, they were saved by a huge, truly massive £65 billion intervention by the Bank of England. But the chaos can be attributed to poor risk management, lack of transparency and clarity about how the risks interlink across different financial institutions, and that led to an inability to adequately and comprehensively stress test the risk exposures of all the players, whether they were pension funds or banks and non-bank sector organizations. I think there are very, very important lessons to be learned, and when I heard some of the interventions earlier from in the previous session, it struck me as being complacent to a very high degree. So I think that the dynamic of competitive deregulation dangerously undermines the interests of pension fund holders and other savers. And with this in mind, I think it's important. I'd like to strongly endorse some of the recommendations that have been made. I strongly endorse that financial services providers wanting QPAM status should notify the DOL, and I think this should be an annual notification of its reliance on QPAM exemption. And I think the DOL should maintain an online listing of all the recognised QPAM exemptions. But I'd go further. I suggest that these exemptions are independently reviewed by experts to ensure that the exempted parties remain eligible for their QPAM status. And as part of that annual notification that I recommend, I think the principals of any exempted entity should sign a declaration stating that they have not engaged in any prohibited misconduct that might render them ineligible to continue to hold QPAM status. And I think that declaration should not be exclusive to their activities within the US. It should be global. Secondly, I strongly support the suggestion that Andreas made about implementing a name and shame list. I'm convinced that nothing will deter bankers or others from misconduct until such time as their reputation is firmly on the line. And thirdly, finally,
thank you.
I'd just like to make
Wrap that up quickly with the third point.
Yeah, if you could just wrap up.
My third point would be more attention needs to be paid to the role of whistleblowers in flagging up concerns about misconduct in space and criminality. I know from my own experience that banks, fund managers and pension funds, they're kind of prone to suppressing internal dissent to the extent that whistleblowers put their careers and their livelihoods at risk by whistleblowing. And they need to be protected from that. And I think this needs to be built into into the safeguards that we put when dealing with QPAM. So thank you for the time, and I look forward to questions.
Thank you. So why don't I kick this off with the suggestion from some of our other commenters with respect to instead of there being ineligibility, that the requirement should be that QPAM clients are notified of this type of misconduct so that the fiduciaries of those plans are able to make a determination and assess the overall kind of scenario and whether or not they should be moving to another asset manager. Is that sufficient from your perspective to at least start addressing some of these concerns with the this larger scope corporate misconduct?
I'd say absolutely not. I think the honest ones are looking to you for guidance to make the choice for them. The details of these criminal convictions and DPAs and so forth are so complex. What I read out, I mean, it's truly horrendous, but it's only a tiny fraction of the horrendous behaviour in that bank, and that bank's not alone. It goes on in a lot of banks, and untrained people are just not up to making a decision for that. They'll just go with the flow. So it defeats the purpose of the ERISA protections.
I think that Department of Labor has a chance to really aggregate its experience in this area and to proactively identify the kind of concerns and misbehavior that ordinary pension fund managers, funds are not in a position to do with this kind of decentralized approach. I would call that legalized dueling, effectively. It's just naive, and this is not a matter where we don't have history. History tells us the Credit Suisse is a glaring example, but there are many others. It's not as if DOL has created a huge burden with this kind of concern. Just the opposite. It's been far too inactive. So I think we have to swing back in the direction of having DOL more active in actually monitoring the kind of serious systemic misbehavior that we're talking about. That's not going to be a burden to pension fund managers. It's going to be a great help when they have to defend the decisions they're making to their colleagues and the incredibly influential people that they're trying to fire.
I'd go further and say that the DOL needs the ability to levy financial penalties to pay for the resources to do the job properly. Properly managed financial penalties and oversight is one of the best investments the country can make to weed out corruption and keep things straight. And in the long term, the honest operators will just be so grateful for it.
If we don't have the ability to levy penalties, what are the alternatives then? Is getting this information out into the light of day, whether it's to say the planned clients, the QPAM's planned clients, or possibly notification to DOL? Is that sufficient to at least move, keep things within line with what the QPAM exemption itself is about?
You do have the capacity for naming and shaming, as Andreas suggested, and I think that's a very powerful disciplinary mechanism. And I know from within the financial services industry, they are very concerned about reputational issues. So you have a powerful tool there.
I think that the idea of having, the SEC has had a success in terms of having the industry fund this kind of enforcement program. And, it does that partly with a kind of financial transactions tax that most people don't know about. But secondly, the idea of actually having the misbehavior paid for by those who are caught doing it is not a bad suggestion. But I think the idea of having levels of QPAM status, in other words, let's have trial periods where people come into the program and they're sort of on probation, but there's some notion that your good behavior will be rewarded. You'll have kind of a frequent flyer list, and then there'll be a gray list where people are, and this is the approach that's been taken with tax havens to some extent. There have been black lists and gray lists and white lists, and sort of segmenting the QPAMs. And reserving absolute condemnation for a tiny fraction that are just relentless. But I think that there's much more the DOL could do with creative regulation that would not be of great burden to the industry. We'd be happy to think with you on designing that system.
I think it's realistic to accept that the DOL does not yet have the power or the authority, even after these things are hopefully all passed, to do what it needs to do. And that's not your fault. But I think realistically, there's likely to be a financial crisis. It needs to do the best it can to help the pension funds survive the next financial crisis. I think it needs a regime where whenever bad behaviour is notified by a QPAM, it is obliged to immediately notify you, first of all, that it's notified, it's found bad behaviour, maybe criminal behaviour, and secondly, then advise of its program to correct that. Risk management is not about eliminating criminal activity. That's impossible for large organisations, but it is about managing it and keeping it at a level where it doesn't affect the stability of the system. And that's what's not happening. Our
overall point here is that some of these organizations that we're dealing with are very large and very, very difficult to manage. They have internal cultures, which I would describe, having worked at several major financial institutions, as a kind of higher immorality. Once you're inside, it's very hard not to comply, not to go along. And to complain. And it's important for that reason to have the Department of Labor able to have an independent perspective on these matters. So
that's why the whistleblower program is so important. That's the most efficient way of getting inside information, what's going on. People are frightened. With the Wells Fargo case, there were 700 whistleblower reports that were ignored before the final thing blew open after about 6 to 7 years. I mean, that's shocking. If the DOL could get the reports, and then at least they're not going to get ignored. Don't think of the perfect answer. The current situation is dangerous. And the DOL, in my opinion, is one of the best organisations to take a balanced, sane view on what's going on. I mean, for God's sake, they rescued teenage kids out of meat factories that have been child exploitation. They're at the coalface of doing stuff for real people. I deal with agents with law enforcement in every country that's significant at all levels, from the very highest to the very lowest. And it's extraordinary the different attitudes that they have. But in the DOL, you do have a much better opportunity to provide a balanced response when you do get real reports of bad behaviour in an organisation.
I would say one more thing. Being a regulator, especially these days, is never going to be a popularity contest that you can win. In fact, if you're doing your job, you're going to have vociferous complaints from the industry. That's part of knowing that you're effective. When Roosevelt appointed Joe Kennedy to come in from Wall Street and run the SEC, there was an uproar on the part of his former colleagues. Joe Kennedy actually knew about the misbehavior, and we ended up having regulations that we had benefited from, requirements of elementary reporting requirements, financial reporting, that is been nothing but constructive for investors. So that's a great example of successful regulation. That's the kind of tough regulatory approach that can be constructive and can actually save financial institutions from their worst their worst propensities.
May I add something here? From my perspective as an AML expert, the enforcement of a regulation will be difficult. For example, in the European Union, there is an anti-money laundering directive. It was enacted in 1991. It's still not enforced in 2022. There is a serious problem with how to enforce laws and regulation, and I think this is a tough one on the Department of Labor.
May I come in on that and just add a couple of comments? A few years ago, I talked, as part of a research program I was involved in for the European Union. I talked with financial institutions across all the major financial centers in Europe, and talking to, off the record, to the senior principals. They all said that they would prefer to be working in an environment of strong regulation and strong enforcement, because the race to the bottom was undermining the standards, including the ethical standards. Getting back to what was said about ethics earlier on, they say it's the lack of compliance and the lack of enforcement that drives the race to the bottom in standards across the sector. So their personal view, not the institutional view, but the personal view was they preferred to have stronger standards and to have strong compliance and enforcement of those standards. All of that was written up in a book about financial fraud published in 2017.
There's no question that you're up against a very powerful industry. I added up the political contributions and the money spent on lobbying by the top 30 pension fund managers, firms we've described, companies like HSBC and JP Morgan, BlackRock, of course. And it's $1.4 billion since 2012 on lobbying and politics. And just this year, it's a total of $92 million from these institutions. So there's no question that they have voice, and they have many of us concerned. We're outside experts. We don't get paid for this. All of the people on the panel this morning, I think, were there by virtue of working for their industry. I'm not questioning their good faith, but I think that you have to have an outside analysis of the impact of these regulations, and not just listen to the industry, because the industry has a history of buying influence, and not all of the players that we're talking about can be trusted.
the comment that we had heard earlier about the fact that if QPAMs become ineligible due to foreign convictions, that it might subject them to rogue actions by countries in the way that they interpret their laws and find the QPAM has violated them. I was just wondering if you had any reaction to that statement from the prior panel.
Chris, hypothetical. There are so many cases in which the Department of Labor could have benefited by looking at respectable foreign convictions. We pointed out the one in Japan. There have been many others, and we're unable to do so within the current QPAM. The idea that Russia, for example, would convict, you'd have to really come down to some very specific hypotheticals. And I can't imagine, we have to really, I think, dismiss that. Is China going to, blind us by dumbing up some conviction of a U.S. A bank? So that's just...
Then on top of that, the DOL has to believe them. You don't have to believe everything.
I think that's incredibly insulting to DOL. I just can't, that you wouldn't be able to discern the difference between a credible, nobody's requiring you to rubber stamp foreign conviction or foreign deferred prosecution or any piece of evidence. All we're doing is allowing you to look and use it in making an independent assessment. And that's just what the federal government does all the time.
If I could just comment on that. When I heard it earlier on, I honestly can't think of a single example, but I can think of an example which turns that argument on its head. Earlier, I talked about an investigation into a subsidiary of the Swiss bank UBS, which was operating out of the Channel Island of Jersey. That's the British Channel Island of Jersey, under a subsidiary called Cantrade. And when Cantrade was investigated by a team, the Jersey courts actually chose to not prosecute. So the investigating team and the lawyers for the plaintiffs, many of whom were US citizens who had lost a lot of money as a result of churning and banking fraud, currency frauds, they turned to the Second Divisional Court of New York. And when UBS heard that the Second Divisional Court in New York was going to go for it and prosecute them in New York, UBS said, no, we would prefer to be prosecuted in Jersey.
Yes,
So it's the exact opposites. And I kind of thought, where do these people come from when they think? And of course, the Jersey court was particularly lenient, and UBS pleaded guilty to criminal recklessness and had a fine of $4 million, which was peanuts. Whereas New York courts would have given a very much more severe, I think, fine, and might well have looked twice at the license arrangements with UBS. So I honestly can't imagine where that comment came from. My experience suggests it's the opposite happens.
If I could maybe just, I don't know what, set expectations a little bit here, or say a little something about the way we look at the world. In listening to your comments, it feels a little bit like you think our remit is a little broader than what it is sometimes. We regulate the pension plan universe, and we're responsible for protecting the interests of private retirement plans. And I think the premise behind the QPAM exemption is, it's a class exemption, and if you're the kind of financial institution that falls within its parameters, you get a pass from one category of transactions that would otherwise be illegal. And before we give folks that pass, we want to make sure that they're the kind of institutions that can be trusted to act in a way that's protective of the plan participants' interests and isn't going to make us regret the fact that they were given a pass from rules that were intended to protect plan participants. But our focus is entirely on what is the interest of plans. We're not here to our job is not to second guess whether prosecutors impose the right penalties, whether other financial regulators got the right kind of recoveries, or to kind of supplement the criminal provisions or anything else. It's strictly about protecting plans. And I think a lot of the arguments, obviously they're a focus on very specific provisions, but a lot of the argument of the prior panel was, in their view at least, however well-intentioned we might be in this exemption, we are in the end going to impose some significant additional costs on plans and well, first on the investment managers, but then secondarily on the plans, without necessarily getting much benefit. And in particular, they're concerned about the indemnification provisions and the like. And that's kind of what I'm looking for. I mean, how do you think of that?
First of all,
issue?
We're not trying to make you into the Justice Department. That's
appreciate it. Yeah.
We're actually trying to figure out what your role should be, short of the libertarian proposal that you be abolished. And I think you were suggesting in your very astute questions to that panel this morning that, look, we are talking about highly, a thin slice of extreme behavior by institutions that have engaged in systematic, recurrent behavior. That's a pretty clear. Now, I would submit that in the case of Credit Suisse, we also have a dramatic example of where the Department of Labor could have acted earlier to be much stricter than it was, and we were right. I hate to say that. It gives me no satisfaction whatsoever to say that we warned you. We told you so in January 2015. Ralph Nader, myself, Andreas, and Dr. Paul were all on that call, and we were there. And
they did the same things then against us as they're saying now.
They could not be trusted. So I'm saying, in these rare events, in these rare cases, you should have authority to act. That's all. And I think that their track record is that this will send a message to the industry. It will help prevent misbehavior going forward. The kind of financial crisis we are talking about here on the margin, people are very concerned about the way major corporations and banks are treating the assets involved in the fossil fuel industry. Are they appropriately reserving for the day that those fossil fuel and coal expenditures, are not going to be of any value? BlackRock, it turns out, is one of the biggest investors in fossil fuels. They have a $10 trillion fund, and their Global Witness this week exposed the fact that they have $8 billion of exposure to deforestation in Brazil. I mean, this isn't good, but it doesn't take much imagination to say the Department of Labor has a role to play in protecting pension funds against these extreme forms of behavior. That's all we're talking about.
And how about with respect to deferred prosecution agreements and non-prosecution agreements in particular? The argument is that criminal liability, at least in those cases, it remains to be proven whether anybody did anything egregious. And so I guess the argument is that maybe a notice should go out to the plans and the participants, and they should be informed of the facts, but it shouldn't be kind of an automatic disqualification from being able to take advantage of the general QPAM exemption, just as a matter of fairness, as I was hearing the argument. Do you have thoughts on that?
I'll defer to my colleagues as well, but quickly, look, I think there are there are DPAs and DPAs, and the industry in general. If you go back to 1998 and you look at the number of deferred prosecution agreements by the top 30 pension funds, we're talking about 390 such agreements. You know, in the case of Credit Suisse, we had 35. If in the case of Deutsche Bank, we had 40. In the case of UBS, 50. Morgan Stanley, 60. HSBC, 28. So I don't think it's any particular deferred prosecution agreement that we're talking about paying attention to that would set off, some kind of response by DOL. We're talking about the collective accumulated pattern that some of these institutions have engaged in over time. JP Morgan, 66 such agreements. So when it begins to add up, and it's more than just an occasional rogue trader in London. Apologies to John. It's always in London, isn't it, John? The city of London has its profound history here. We're talking about systematic behavior that cuts across borders and is, bigger than a bread box, more powerful than a locomotive. I mean, you just, you know it when you see it, as one Supreme Court judge, I think Justice O'Connor once said. That's what we're talking about. Reserving this kind of, there ought to be some sanction for this kind of misbehavior, and it's outrageous that there isn't.
There's a bunch of things we can do to improve the situation. First of all, none of them are automatic. And look, I read through every submission that was there, 30 or 38 or whatever. And look, I was kind of shocked to the core about the attitude and the lack of competence. I'll say it quite bluntly, that they took what you regard as an adversarial approach to what is really an inquisitorial inquiry. We're trying to find the facts here. We don't need people lying and making things up. And I found it full of stuff that was unreliable. And I mean, there were obviously some basis for legitimate comment, but it's too hard to separate the truth from what is called the manufactured outrage that's become common in the financial industry. And I think they need to take responsibility for that. If they're going to come here and waste your time with things which is unreliable, then they kind of got to take, there's consequences for that. None of the things are automatic. Even a criminal conviction, Credit Suisse got lots of extra second chances on its criminal conviction. As John said, it's the accumulated assessment of what's going on. So you're assessing, you got a better, more reliable database to look at. The other thing is, if we turn the responsibility back to them where it should be, it's their job to stop criminal activity. It's their job to report to you criminal infractions before they become public. It's their job to tell you what they're doing to fix it. It's their job to persuade you that they are being responsible when they discover crime in their bank. It's not a capital offence to find there is crime in the bank. It is very serious when they protect crime in the bank. That's what's going on.
Also, I spoke about having a requirement to make an annual declaration, because in too many cases, when it comes to declaring prohibited misconduct or whatever, materially misleading information is provided, or simply materially important information is withheld from the DOL, whichever authority is the reporting authority. It's the withholding of information, and the systemic pattern of not providing information about systemic failures elsewhere or systemic misconduct elsewhere that should be of concern to the DOL. And I think that's why I think an annual declaration saying, here we are, we can confirm either that we've had no instances of prohibited misconduct, or we've had the following instances. That allows the DOL to determine whether information is being provided willingly or is being withheld.
See, there's another more severe danger, and I don't know how you're going to tackle it, and that is the highly complex financial products that are whizzed around the pension funds, which you could almost say no one understands them except the creators, and some of them are likely to be, deceptive or illegal or fraudulent or whatever, but they're just too complicated to pull apart. And the funds themselves don't understand them. And while things are stable, the stable economy, it's fine. But what they do is they're calculated to protect the issuer, and that the cost is borne on the recipient, that is the pension fund. And when things collapse, of course, it's kind of too late to fix it because, with 100 pages of legal print, a pension fund was likely to go bankrupt before it could get a court judgment, if it was even able to do it with all that legal print. It's very complicated what was going on in the financial world, and a lot of dubious justifications for it. It's not like the old days where, a share bought a share in a company. It's nothing like that anymore. I don't know what you're going to do about it, but from my first thought, somehow you got to sense the honesty of the corporation and give yourself some sort of honesty rating to start to work out a strategy to deal with it, because in the next financial crisis, these are the things that are likely to collapse. And people have all sorts of explanations later on, but sorry?
No, I'm just going to underscore what you're saying, but also just draw the thing to a point, which is that we're living under fast capitalism. We just saw the FTX collapse, going from a $32 billion market cap in February to zero. Lots of exposure there on the part of financial investors, including some pension funds like Louisiana. There's nothing the DOL could have done to prevent that kind of fast capitalism. But I think that's why it's so important for them to raise the game, because they have to think creatively, not about what's happened in the past and the existing QPAM regulatory scheme, but what is going to be necessary in the next 5 years to protect against some of these, sort of innovations that are just percolating across the globe. And I don't think they're prepared. I don't know that this set of proposals is great. It's a good start. But it's like 200,000 tax lawyers at the bottom of the ocean. It's just a good start.
Question. So we've heard from applicants, like there may have been misconduct at one affiliate, but the QPAM itself had separate, wasn't involved, has separate compliance, separate legal, separate operations. They've come to us and said, well, the QPAM's completely insulated from the misconduct. And the department, you should take that into consideration. And I just wondering your thoughts on that, how meaningful that kind of representation is.
Paul, do you want to take that?
Yeah, I've thought about this problem quite a bit. And look, take an analogy in the normal world of justice. Our world of justice is very imperfect. US has more people in jail per capita than almost anyone else. It's not very effective, but on the other hand, if you didn't put people in jail, you're liable to have a worse situation still. Scandinavian countries have a better system where they keep people out of jail, but they have a society that's way more friendly to each other. They don't have the entrenched racist and class problems that the USA have, and they don't have guns. So there are things that are possible elsewhere, but not yet possible in the USA. So where you have a justice system, where you have law and order, you have to have some sort of consequences, and crime and punishment. It's going to be imperfect, but without it, the chaos, the anarchy is even worse.
But have they been able to insulate their QPAMs? That's the point of the question, I think.
Well, the thing is, they lie all the time. When Credit Suisse was at the first meeting, I was talking to the assistant legal counsel at who employed Credit Suisse, and they said, look, they didn't know themselves which entity they belonged to. At the hearing, they swore that this entity was quarantined from the other entity. But the other guy said, no, they got no clue themselves who they're working for. So, and they, unfortunately, to call them all liars is a little bit impolite, but honestly, you can't believe what they say.
So I think the idea is that we would have a presumption that would be rebuttable. And, that's a tricky fact question and how you get information in a particular case. But in principle, there could be, hypothetically, some QPAM that was insulated. It just depends. But I think what we're saying, generally speaking, is in the case of really serious systemic misbehavior like Credit Suisse, that you usually can tell from a slight distance that this institution is not trustworthy, and you look beyond any one particular set of facts. And I think that the whether they've structured their QCAM one way or another is just one piece of evidence.
Jim, you talked earlier about a kind of moral lapseness that infests many financial institutions, and I completely get that. Here in Britain, we talk about a fish rotting from the head. In other words, if you have a subsidiary of an organization which has gone off the rails more often than not, it's gone off the rails, and the directors know it's gone off the rails, but it's gone off the rails precisely because the directors wanted to do that. There must be some kind of sanction against the people at the very top, the directors. Within any international financial institution, it must be the people at the very top who take responsibility for the failings of subsidiaries. So I don't think it's possible, to answer your question, Ms. Motta, I really don't think it's possible to separate one activity from another, because I think they all intersect, they all work with one another, they work across borders in many, many ways. And I think that the moral codes that operate within these organizations come from the very top.
That you have to, drive on one side of the road or the other. Now, under US law, the racketeering statute, RICO, they specifically say that a subsidiary is not distinct from the parent company. They cannot form an enterprise and regarded as one. Neither system is going to be perfect, but that's the US law system. And you have to stick with some system, and you're in the USA, so that's the system you've got.
Whether that's you answered your question. Your question is basically unanswerable.
I'm good at those. Yep.
In the abstract, you're good at those. So, by the way, I really do want to say that it is great that the Department of Labor is holding this hearing, and that you are actually entertaining. We don't expect to win. We expect the same result, basically, in 2015 in terms of reform. I hope you're able to make all this happen, but it would be a great victory. But we're up against some very powerful opponents, and they're technical experts. But it is terrific to see you're at least asking the right questions. What value added does the Department of Labor QPAM regime provide? And how are we going to reinvent ourselves to be useful to all of these clients of ours, our customers, not just the ultimately the pension fund recipients. So that's the question. And the rest of the world now depends on the United States to get this right, because of these top 30 funds, asset managers, 24 of them are US based. The role of the dollar here has been a big factor in that, and the growth of the tremendous growth of US based assets, and our, very low interest rate policy. But I think we're now going to be expected on the part of the rest of the world to look to us to set standards like we did in 1977 with the Foreign Corrupt Practices Act, in this tricky area of how do you protect pension funds when you have corporate misbehavior. Good luck.
Yeah.
So Aaron, is it time to bring this one to a close?
I don't have any other questions, so unless others do, we're a couple minutes ahead of time, but this might be a great time to break for lunch, unless, again, someone else from DOL has any additional questions.
I don't have any additional questions. So what time will we be reconvening, Aaron?
We reconvene at 1:15, so we've got a nice long lunch for everyone. I do just want to point out very briefly that if people do reconvene early, to try and minimize any the idle chit chat, we won't be on the record until 1:15, but it'll just help us continue to move the hearing along if kind of wait for dialogue until the hearing reconvenes at 1:15.
Opportunity to have dialogue with other panelists later on, or is this it's sort of segmented by group?
Yeah, not through this interface. This is for us to interact with you.
And just refresh our recollection about what the procedure is from here if we want to submit new comments or revised comments.
Oh yeah, sure. So the comment period is reopened as of now, effectively as of today. I think some of you signed on a little bit late. Assistant Secretary Gomez noted that the comment period will be open until December 16th. That is subject to us getting the hearing transcript posted on time, but we will post a Federal Register notice letting folks know when the official comment period close date is going to be. So you can start submitting comments as soon as you get off today's hearing if you desire, but it will be open for at least 30 days.
Great. Well, personally, I'm taking a break, but we are good luck with this, and again, thanks very much for holding it.
That's
Thank you. Yep.
Thank you.